Hey, good evening, everybody. Good evening, YouTube. It's Tasha Simmons. I have not made a video as long as this one is about to be in 2, 3 years. My last video was made in regard to the debate held between Ruslan KD and the lead attorney in regard to family custody issues. And I felt really compelled to make a video about it because it intersected so many different things that are really, really important to me. Um, Christianity, the law. I am still a licensed Florida attorney and a Florida Supreme Court certified family law mediator. Um, and it also, I'm going to stop umming so much. It also involved, or at least bordered on, or involved people in the Christian and ministry and Christian hip hop community, which I'm very close to, is very near and dear to my heart. And since the last time I made a video, some things have come up that really compelled me to want to sit down and do another discussion like this. But life was lifing, like real hard. And I have a testimony. I have a few testimonies. God is good, but I just could not tackle those. But this particular situation that has been going on for the past, well, we headed into a week. We headed into over a week. As far as I know, this started a while ago. This started years ago, but this particular round of communications regarding these issues uh, took on another life, if you will, around May 29th, as far as I understand. All right, so I just found just an opportunity to engage in a really cute, fun, and novel discussion about the legal issues that could potentially arise from this, given that a lawsuit was mentioned last night on one of the lives. And honestly, I actually do want to actually discuss the use of scripture that's been going on in this situation as well. As a believer, I'm very concerned about that. And I have some things to say about that. I hold the law of God to be the supreme law of all of creation, not just the land, but of all things. And so I would love to see God's law handled correctly. But before we get into all that, let's just have some fun discussing just the regular smegular law, regular degular law. All right. So if I didn't say my name, I don't remember saying it. I'm Tasha. Okay, Tasha Simmons. There's my thing, if you can see it. But I'm a daughter of God, first and foremost, daughter of Yahweh, follower of Christ, and again, a Florida licensed attorney and mediator. So let's go. I was up late last night just talking to a friend when I saw Tiphani Montgomery went live. And I was astounded and preemptively dreamed at the thought that another live was being done. And it was pretty late. And all of the videos that have been going on about this situation, I haven't really been stopping to watch them. The ones that I have wanted to sort of glean things from, I've copied and pasted the transcript from the YouTube video and asked ChatGPT to summarize it for me. But this one I watched, and I found it eyebrow raising, to say the least, that the term "I could sue for this" was used while Ms. Montgomery, or Prophetess Montgomery, was discussing the statements that were made about her. And it just got me to thinking, because as much as this thing has been pulling my attention throughout the week, I did not even stop to think, because I'm just, working. Like, oh, can she sue? Like, is she even thinking about that? She thought about it. She's saying she's not going to do it, but she does imply at least 3 times that it's something that is actionable that she could sue for. And so let's get into it. Is that the fact? Let's see. So let's set up the case. All right. You first need what's called a controversy. This versus that, generally speaking. So our plaintiff obviously would be Minister Montgomery. And then you have your defendant. In this case, defendants. All right. Now, who are we suing? That depends on what you're suing for. Okay. So what was mentioned when I was watching was defamation. She said she could sue for defamation. Defamation is the uttering of a false statement about another that is published to a third party or communicated to a third party that causes damage and is false. All right. Now, in a civil case, this isn't a criminal case. Okay. When one private person is suing another, it is not criminal, okay, in any way. And the standard is not beyond a reasonable doubt. You don't have to prove your case beyond a reasonable doubt. Okay. The civil case. So, what are the statements? That's the first question that we have to ask. So, we have number one, she's a witch. Number two, she's a false prophet, and I'm just going to put / false teacher. And if you could think of any other statements that she made, I didn't publicize or tell anyone I'm going live. So I don't know what's going on. I can't even see what's being typed at me right now. But maybe I'll log in somewhere else and check the chat. Because if there's anything else she's accused of being called, let me know. As far as I know, the only thing she's saying she's being called is a witch and a false prophet / false teacher. So that tells me that her defendants would be Dr. Eric Mason of Epiphany Church and my understanding is that she is accusing Preston Perry of calling her the false, just falsely for short. Okay. Now, there's a lot of Jackie Hill Perry mentions and interactions, or at least I'll say unilateral interactions in this situation. But I will say at the outset, I do not see how Jackie Hill Perry lands on the list of defendants in this case, because there has to be a statement for there to be defamation, whether it is written defamation, which is libel, L-I-B-E-L, or slander, which is spoken defamation. Okay, what did Jackie say? Now, I'm hearing a lot of accusations that she's been subbing Prophetess Montgomery, but you know, when you say someone is subbing you, you're admitting that you're reading into what they're saying and assuming it applies to you and assuming what they mean. So would I bring a defamation case against Jackie Hill Perry based on her typing yikes or allegedly subbing me? I would not do that. So I think for the purpose of our discussion, I think we're good with just sticking with Dr. Eric Mason and Preston Perry as defendants. Okay? Boom. All right. No other plaintiffs beside Tiphani Montgomery, as far as I have heard. So let's move on now to what the plaintiff has to prove. Now, before we get to proving anything, who's going to hear the case? All right. Where's everyone located? I will admit, as much as I love the Lord and walk with Jesus and love entertainment and music and all of that, I'm not very familiar with these individuals. Like, I've known of the Perrys since P4CM, before they even got married. Dope poets, awesome ministers now. And I've always been aware of Epiphany as someone that has been a super fan of CHH since its inception. Before its inception, really. And so, but I've never been there. As of 2020, I know people who go there and who used to go there. Okay. So I know Dr. Eric Mason is in Pennsylvania, but for the purpose of discussion, since I am a Florida attorney and I do not practice in any other state as of now, but Florida, we're just going to pretend Epiphany is in Florida, which, I mean, come to Orlando. So we're going to put Dr. Eric Mason in Florida. for the purpose of discussion, just for the heck of it. My understanding is that Prophetess Montgomery is in North Carolina, and the Perrys, I believe they are at, they're in Georgia. Last I heard, they were attending 2819, which is Michael Stephen Phillip, the dude with a lot of names, Michael Anthony. I know I got it right in my thumbnail, but I always trip over his name. So they're in Georgia. So when you have different cases like this, what you might find yourself doing is filing in federal court, right? So each state court, they have their own little system, but federal court, that's an overarching system for basically the whole nation. All right, I'm trying to make this very simple. And so even though there are different federal courts located in all over each state, it's one federal system as opposed to 50, 51, if Canada becomes a state, 52. Okay, instead of their separate state systems. So let's go from there. Let's say she sues Dr. Eric Mason because clearly he has made more statements than anyone else involved as far as her claims. Okay, so let's hear this case in the Southern District or in district court, and we're going to file it in one of the Florida districts, Southern District, Middle District, who cares, whatever. Alrighty, she can do that. You can do that under what's called diversity jurisdiction. You can go to federal court if the person you're suing is in another state or if you're suing for a certain amount. All right, so let's bring it here because I'm the one talking about it. All right, boom. So we're in federal court, we're in Florida, or even Georgia, because the 11th Circuit federal court that covers Florida also covers Georgia, which is where the Perrys are. So you can bring a case where the defendant is and where the alleged damage occurred. Okay, so we're in federal court down here by me. Now, what does she have to prove? Well, of course, we first have to prove that the statements were made. Now, for Dr. Mason, that's going to be fairly easy. I saw him call her a witch. I heard and saw it. I am also aware of the video where he is in a service referring to her as the church, basically the church equivalent of an industry plant. And the phrase he used for that was a demonic plant. Okay, so he said that in church to his folks. That video is online. And on TikTok, on live, he referred to her as a witch. Alrighty. Now, there is another post that I am aware of that exists on his Instagram account where he is posting in general about his belief as far as the existence of modern day prophets, not the gift of prophecy, but the office of a prophet and whether it still exists today, what his litmus test is, and where everyone who claims to be a prophet nowadays falls in his analysis. Okay, and then you got a whole bunch of mess in the comments under that Instagram post. However, no one was particularly referencing that post. So if you really want to move forward on something, you're going to want to move forward on what actually came out of his mouth. So we're going to stick with the TikTok live, and we're going to stick with that church service video. All right. Now, when it comes to statements allegedly made by Mr. Perry, and using the word allegedly just reminded me to give you my disclaimer. Guys, like I said, this is a fun intellectual exercise. I am only licensed in Florida, and this is not legal advice. Thank you. This is not legal advice for you, none of y'all. Great. I'm not your attorney, and I'm not vying to be. So were the statements made? We check, Dr. Mason. Statements were made. Okay. There's no plausible defense there. Now, was this false statement made by Preston Perry? You know, until last night, I was almost sure it was. What I've been hearing repeatedly throughout the week is I have a phone call recorded And as soon as I got on the phone with him, he apologized for calling me a falsie. And last night, the phone call, for whatever reason, I don't know who asked. I don't know who asked, but the recording was played. I think it was just burning a hole in her head. I didn't see the need to play it, but it was played. I listened to it, and then I went back when I had more attention to give it, and I listened to it again. I did not hear him admit to calling her a falsie. I did not hear him apologize for calling her a falsie. I did not hear him promise to post an apology for calling her a falsie. What I heard was an explanation of how she and others could have thought he was calling her a falsie. I'm talking about the phone call, not the live. I never saw that live. I'm talking about the evidence that is before me right now, which is the phone call and the statements of both parties, or at least a statement of the plaintiff. As a matter of fact, on the call, he denies calling her a falsie and explains what happened, which might have led to what appears to be a misunderstanding. So if she wants to prove he made that statement, that call don't help. It does not help. That is not helpful. Okay. Now, if I'm going to say, given what I heard on the call, it's more likely than not, I don't even know if it gets you at that point. All it does is that it proves that there was some discussion about this. But if he went on the stand and said on the stand what he said on that phone call, he would basically be defending himself. He wouldn't be admitting a doggone thing. So what you want to do, if you want to prove he made the statement, is find that live, if it's still up, which I hear is not. Find the live, find somebody else who saw it, do something, but that phone call ain't it. And as an aside, North Carolina and Georgia are one consent party states for the purpose of recording a phone call, but they are two different states. When you're talking about an interstate call, sometimes that triggers different rules, and it might have been the case that you were supposed to get his consent before recording. I don't know that she did that. So by going live and playing that last night, now she's already been saying she's had the recording, and now she proved she had the recording by playing it. So I just hope for her sake that if calling him in another state or from another state triggered the responsibility to get his consent, well, I hope she got that. So, because I don't, like I said, I don't know them, but I don't think they're in the same state. Now, if they were at the time of the call, fine. That's an aside. So now back to the defamation case. So now we're past the point of what are the statements that you're bringing to the court, and are you proving that the statements were made? I just discussed her likelihood of success of proving the statements were made. Now we turn to the question of if these statements are actionable, right? Are they defamatory? So what does the law say about a defamatory statement? Well, this is funny. Oh, this is funny. All right. So if it causes you damages, reputational harm, okay, there are some things you don't even have to prove damage. It's called defamation per se, or slander per se, or libel per se. I don't see where there are any of those kind of statements made here. So she is going to have to prove damages once we prove liability. So in that vein, I want to take you now to a case I found out of, let's see. And again, don't bring just any case to court if you're in a case, guys. I'm bringing this case up because it contains some good explanations of the legal concepts that I want us to explore here. Not because it's persuasive, okay? This is a state case coming out of Iowa. I just think it restates the law pretty concisely, pretty well. And I'm going to share the facts of this case with you as well. It's Kleinstein, okay, versus Iowa Conference of the United Methodist Church. So this appeal involves a church-related controversy, an area of discord traditionally considered off limits for civil courts. Why is that? Why is that? Because even if you have a valid defamation claim, if this is involving church affairs, the interpretation of doctrine, spiritual matters, or a church managing their internal affairs, the court isn't going to touch that. That's called the doctrine of ecclesiastical abstention, okay? And it's a part of the religious protections afforded to us under the Establishment Clauses, the First Amendment of the Constitution, all right? So that's not to say that just because it involves church, the court is never going to deal with it, but we have to sort of get into what's being said and the context in which it's being said and who it's being said to in order to determine, hey, do we need to apply the doctrine of ecclesiastical abstention here, or can we proceed with the case as a normal defamation case? All right, and again, that is why I read this case. Not because it's authoritative in federal court, it is a state case from the other side of the country. All right, so the facts are not disputed, writes the court. In March 1999, Jane K, I'm just going to say K so I don't butcher this last name through the whole video, and her husband Glenn were members of Shell Rock United Methodist Church, we call it UMC. The defendant, Gerald Swinton, was the UMC district superintendent. Prompted by reports of strife within the congregation, he, who's an ordained minister, we'll just call him, what's his name? We'll just call him Gerald. Okay. He visited the Shell Rock Church one Sunday morning. He then wrote the letter that is at the heart of this controversy. Okay, so here is the statement. It all turns on the statement, right? A few months ago, this is the letter I'm reading now that Jane is suing about. A few months ago, I attended worship in Shell Rock. Gerald, the defendant, attended worship at Shell Rock, and I rejoiced to see so many young families in church. I was in despair when Jade K made an effort to whisper scornfully to me that this pastor must leave Shell Rock. Folks, when is enough enough? When will you stop blaming negative and unhappy persons among you from tearing down the spirit of Jesus Christ among you? You know whether a person has the spirit of Jesus or Satan by their fruits. Does any of this sound familiar, y'all? I am distressed and perplexed why people have tolerance and compassion for anyone who habitually tears down the body of Christ by habitually sowing discord and pain. Last paragraph of the letter. When the congregation of Shell Rock is ready to acknowledge they allow the spirit of Satan to work in their midst, express some contrition and seek help, then help will come. So that's Gerald's letter, the defendant. So Swinton's letter, Gerald, his letter went on to advise that he and the staff parish committee would call a church conference in accordance with established disciplinary procedures to propose that Jane K be stripped of church offices. It is understood that if she continues to cause dissension, she will be asked next to leave the Shell Rock community. Okay, so the K's responded by filing this lawsuit. Their petition claimed that the letter falsely attacked Jane's integrity and moral character, causing damage to her reputation in the community. Glenn sought damages for loss of consortium. I'm not going to get into that. Following discovery, I'm not going to get into what that is, the defendants moved for summary judgment. I'm going to keep this short and not get into that. But basically, the defendant is asking you, okay, Your Honor, listen, what she said happened. That still doesn't mean she's entitled to damages, and still doesn't mean I committed defamation. So just throw the case out. That's what that means. So they conceded for the purposes of the motion that the statement about the spirit of Satan referred to Jane K. They argued, however, that the phrase is a purely ecclesiastical term. So here the defendant is trying to get the court to throw the case out by invoking the doctrine of ecclesiastical abstention. Basically, stay out of church folk business. Okay? The court doesn't need to be in this. So that's what they're doing by making that argument. All right? That it derived its meaning from religious dogma, thereby preventing the court from adjudicating its impact in the context of a civil suit for defamation. The district court agreed, finding it was constitutionally without jurisdiction to entertain the controversy. Okay, so the court that they filed the case in fell for it. Okay, they took the defendant's argument, and then Jane K went to the appellate court, right? They went to the next court up and said, hey, y'all got it wrong. And now this court is writing the opinion that I'm reading to you. So now they're about to discuss the issue. So the plaintiffs now, they concede that the free exercise and establishment clauses of the federal and state constitutions preclude the civil court from interfering in the disciplinary and governance matters of a religious entity. They urge this court to find, however, that the defendants exceeded the protective confines of these clauses when they published their humiliating and disparaging remarks to individuals in the local community who were not members of the church, nor allowed to participate in the disciplinary proceedings brought against Jane. Now, why does that matter? Because ecclesiastical abstention covers some of the elements of defamation. You can make a statement, and the statement is not nice, and it might harm the reputation. But if it's made to only those who need to know on a need-to-know basis so that decisions can be made, maybe by like the church board or about matters internal to the church, then the court is not even going to get to the question of, is the statement true or false, or was it damaging? They're not going to get that far. They're going to abstain from hearing the case, okay? So in this case, and I'll spoil the ending a little bit, they were able to proceed on the case, because that's what this case is about, is can we proceed? This isn't about who ultimately won. The way I see it, either side could have. But this case is about, can you proceed on this case past the doctrine of ecclesiastical abstention? All right. So this is what the court says. This is how the court answers the question. By its very nature, the controversy before us implicates the establishment clauses of the federal constitution. Okay. And this state, like virtually every other jurisdiction, avoids interfering in purely ecclesiastical matters. All right. And then they're quoting another case by saying, it is a general rule recognized here and in other jurisdictions that ordinarily the courts have no jurisdiction over and no concern with purely ecclesiastical questions and controversies, including membership in a church organization. And even though it's not written here, it also includes interpretation of doctrine, teaching of doctrine, and spiritual matters and things like that. Okay. However, okay, they do have jurisdiction as to civil, contract, and property rights, which are involved in or arise from a church controversy. Okay, so it's not government get out just because this is a church, but what kind of, like I said before, what kind of dealing are we talking about? Plainly, our courts could not entertain this case if it involves solely the discipline or excommunication of Jane K, right? Nor would her claim be viable had the matter been divulged solely to the members of Shell Rock UMC. Here's the issue right here. The fact that Gerald's communication about Jane K was published outside the congregation weakens this ecclesiastical shield. First, otherwise privileged communications may be lost upon proof of excess publication or publication beyond the group interest. Now, this case with Epiphany Montgomery does not involve her being a member of that church and being disciplined or possibly excommunicated by them, but that's not the crux of the matter. That's not what the case turns on. Okay, in this case, they were able to get past the shield provided by the ecclesiastical abstention doctrine because they published it outside the church. So both of these statements were put on the World Wide Web. Okay, the witch statement by TikTok, via TikTok, and the demonic, the very wild demonic plant statement. I'm not laughing because it's funny. It's just, you got demonic plant over here, you got demonic compassion over there. Like, what are we doing? Right? So that was put on YouTube, as far as I know. I saw the video. I don't remember what platform it was. All right. So that's gonna be a problem for defendant Mason, for sure. For sure. Okay. So the defendant's counter. Hold on, let me grab my place. Yeah. I like this sentence. I don't really need it, but it punctuates the point very nicely. So I'm just gonna include it and move on to the next point about what was actually said about the plaintiff. So if publication solely to church members justifies ecclesiastical status for otherwise defamatory communications, then proof of publication to non-church members arguably supports the opposite conclusion, writes the court. I think that says it. Okay. So in this case, Gerald didn't just send his letter to Shell Rock UMC. He sent it to the entire neighborhood. Did I leave that out? Wild. All right. Defendants now counter that publication to non-church members is irrelevant here. Their defense rests on the general rule that defamation actions are precluded by the First Amendment. We already went through this discussion. Now let's get down to the argument over what was said. The contention brings us to the dispositive question on appeal. Okay, so when the court says something is dispositive, it means this is for all the marbles. The whole case, what we're going to decide, rests on the answer to this question. Well, this brings us to the dispositive. I need to like have a pointer or something so I don't lose it. Question on appeal. Whether the phrase spirit of Satan has a secular meaning. Because if it has a secular meaning, boom, that's another way we can get past the shield of ecclesiastical abstention and proceed on the defamation case. All right, I'm going to go have a lady minute and I'll be right back. All right, thank you for that. I am back. All righty. So that takes us to the dispositive question. All right. Do, 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 do. Does it have a secular meaning? Okay. So in this case, the phrase at issue is spirit of Satan. Okay. Now, yeah, of course, it's not the same statement as witch or false prophet, but we're going to take the analysis that the court uses here and apply it to this situation. Okay. So you and me will be the jury. We'll be the trier of fact. All right. Defendants rely heavily on an affidavit prepared by Reverend so and so, professional. So they called it an expert. The defendants called it an expert. Okay. So they got a religious expert, a professor of historical theology, okay, and Wesley studies at the University of Dubuque Theology Seminary. Okay, Professor so and so says that terms such as Satan and devil have their roots in religious doctrine. His affidavit also reveals that these terms have evolved and now imply a variety of meanings between and even within religious denominations. Thus, in his words, to determine within any specific ecclesiastical context whether the use of the term spirit of Satan is defamatory, it is necessary to determine the meaning of the term for the religious community or body. So again, they're throwing up that shield again. Now, here's what the court says in response. The weakness in them relying on that expert opinion is that the publication of the letter was not limited to the religious community or body. Given the nature of the plaintiff's claims, the proper focus of our inquiry is not the meaning of spirit of Satan within the ecclesiastical context, but to determine whether the phrase has a secular meaning. In other words, could a fact finder, you and me, determine whether Jane K was defamed without resorting to theological reflection? All right. So then what's the next thing they did? What's the next thing they did in order to, how do you know if someone can take a statement in a certain way without having to get all theological about it? How do you know? Well, this is what the court did. They opened the dictionary. So perusing the dictionary convinces us that the church term used by the officials, I'm not going to read that sentence. That's going to give away the end. All right. Satan is defined as the great enemy of man and of goodness. The devil, usually identified with Lucifer, the chief of fallen angels. Webster's New World Dictionary is where they got that from. Definitions of satanic and Satanism include characterized by extreme cruelty or viciousness and innate wickedness. Webster's Ninth New Collegiate Dictionary, okay? Devil has many dictionary meanings, including an extremely wicked person, a fiend, and a person who is energetic, mischievous, daring, or clever. American Heritage Dictionary. The word spirit is defined as an animating or vital principle held to give life to physical organisms, or more simply, as an inclination, impulse, or tendency of a specified kind, okay, or mood. That's Webster's Ninth New Collegiate Dictionary. We conclude from these definitions that the phrase spirit of Satan has meaning in secular as well as sectarian contexts. Our conclusion is fortified by considering other cases in which associating a party with Satan has become an issue. And they quote those texts. All right. And so the court basically is saying it has a secular meaning and it is common. The meaning is common. We all know what it means. And it's largely unflattering. Now, Let's do that. And there's actually a case where someone is being accused of being called a witch doctor. Well, if we have time, we'll get to that, or maybe I'll just break this up. But let's just go to Webster's Dictionary or dictionary.com. We like Webster. Let's go to Webster. And put in witch. A person, parentheses, especially a woman, in parentheses, who is credited with having usually malignant supernatural powers. That's 1A. 1B, a woman who is believed to practice usually black magic, often with the aid of a devil or a familiar, or a sorceress. 2, less commonly witch, a practitioner of witchcraft, especially in adherence with a neo-pagan tradition or religion, such as Wicca. 3, a mean or ugly old woman, such as hag or crone. 4, a charming or alluring girl or woman. Really? Yeah, I never heard it used like that. 5, witch of Agnesy. Sure. Okay. Witch like witchy. Sure. Okay. So I want you to listen to that definition and tell me, does it, similarly to the court's definition of Satan, is it unflattering? Is it common? Right? When we're insulting someone, and the fact that it might be an insult is actually good for the defendants in this case, but we'll get there. Right? But when it's hurled at someone, it's usually hurled at a woman. Okay? Even though men can practice witchcraft, sometimes they're called something else. You don't typically hear of a man being called a witch. Okay? Now, the context in which it's set in the Epiphany-Montgomery case, it does not appear to be a throwaway term like, oh, that old witch, I can't stand her. Right? After he uses the phrase, at least in the video where he actually says her full name, the one where he's in the church saying it, he goes into her prophecies are off, da 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 da. So he's talking about her as a witch in the spiritual sense. Now, this is sort of a little more nuanced than the use of the word Satan, because in some sense, to be a witch means you are a registered Wiccan, right? Which is something that is provable. A statement at the heart of defamation litigation has to be something that is provable as false or true to be actionable. It can't just be opinion, okay? A lot of things are a defense to a tort, all right? So to the tort of defamation, truth is an absolute defense if you can prove something's true, right? And if it's something that's not provable as true or false, it's some abstract opinion that is based on a fact, but what you're saying is an opinion, that's not actionable either, just under the First Amendment, church or no church. The First Amendment protects our right to speak our opinion, okay? It does not protect us in making up facts we know to be false and disseminating them. Alrighty. So while while I do not believe he was making a pure statement of opinion, I don't think that he was, well, I don't know. I mean, a witch can be a Wiccan or someone who's just practicing witchcraft. He is saying that she practices witchcraft by calling her a witch. That is arguably a factual assertion. He's basing it on facts, which that fact leans me in the direction of, okay, well, it's an opinion because it's based on a fact. Her prophecies are off and all the different things he rattles off about her, da 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 da. And every time she uses a scripture, it sounds like she's trying to curse somebody. It always ends up in some type of because you don't believe I'm a prophet, this bad thing is going to happen to you. To me, that's witchcraft, basically, is what he's saying by calling her a witch and explaining that afterwards. So to me, that sounds like opinion. And it also kind of sounds like it waxes on the doctrinal side, and the court isn't going to get into doctrine. Okay. So I think he has enough of a defense. He has enough of a defense to win the case, but he doesn't have enough to invoke ecclesiastical abstention in order to get the case thrown out. So the case would proceed, but I believe he would prevail. Okay, whether she has suffered damages or not, it would proceed because it was posted on the interwebs, if for no other reason. Alrighty, so is there anything else from this case? So basically the conclusion in the Jane K case was, because we are convinced that the phrase spirit of Satan has a secular as well as a sectarian meaning, and because the accusatory phrase was used by defendants to describe the plaintiff, Jane K, in a communication published to more than just church members, we hold plaintiff's claim of defamation should not have been dismissed by the district court on constitutional grounds. Therefore, we reverse and remand. Basically, we're undoing your decision and we're sending it back so that you can have it out. Whatever happened to JK, I don't know. Go find out. All right. So that is the case. Now, I think her case against Preston Perry fails at even proving a statement was made, unless and until she could come up with that live. But if that live sounds anything like what he described in that call, he didn't call her a false prophet. And even though he also was over publishing, meaning not just publishing to his church community, he was giving opinion on that. So I don't think she prevails against either one of them. And I loved talking about that. I really did. So what I want to go through next time I get on here is counterclaims. Can Dr. Eric Mason sue her? And for what? Can Preston Perry countersue her? And for what? Can Jackie Hill Perry sue her? And for what? Yeah, the next video will just be like, who all could sue her? Because I think in the next legal video, I want to talk about, yeah, everybody who could sue her. Can Beyonce sue her for calling her a witch? I call them the T-Hive, Prophetess Montgomery supporters. Because a lot of them are former Beehivers, and it shows. It shows. Can the T-Hive sue her if they went on these Year of the Bride fast and then never got married? Let's look into that. And finally, can Megan sue Tiphani Montgomery for slander? I've seen a lot of references made by Prophetess Montgomery that this person has this spirit, that person has that spirit, particularly Jackie Hill Perry and Megan, I think her last name is Ashley. I find those assertions to be very troubling, especially said and spoken in proximity with phrases like there's gossip in the green rooms. That's very troubling for me to come from the mouth of someone who says they're a prophet. And maybe one day I'll speak to that side of it. But next time we get together, let's just talk about if they can sue her for it, and do they have a case? Alrighty. Before I do that, I do have a blurb on how the scriptures are used. That's in the next video, and then I guess the third video, and I guess this is a series. Is this my first series? The next video, the third video in this series will be about Montgomery as a defendant. Okay, I had fun doing this, and I hope you have fun watching. Stay blessed, stay safe. Love you. Bye.